Welcome to another episode on cryptocurrency regulation. Uh, for this particular episode, I'm going to take a look at the case of Securities Exchange Commission versus Ripple Labs, Bradley Garlinghouse, and Christian A. Larson. My name is Thomas Plunkett, and I put my email address here. I'm an attorney with the Virginia State Bar. I'm also admitted to the U.S. Patent Bar. I've taught computer science for several universities, and I myself have taken graduate courses from a number of different universities. Including taking graduate courses in blockchain from Stanford. I have a Master of Science in blockchain and digital currency from the University of Nicosia in Cyprus. I also have a Master of Science in computer science from Virginia Tech, and I have a Bachelor of Arts and a Juris Doctorate degree from George Mason University. And I'm a published author on topics relating to blockchain and computer science. So let's talk about the background of this case. And in particular, we're going to talk about the XRP ledger and Ripple Labs. So back in 2011 and early 2012, three people who were really interested in Bitcoin, Arthur Brito, Jed McCaleb, and David Schwartz, developed the source code for a cryptographically secured ledger, which was somewhat based on Bitcoin, but also added some innovations and improvements. And that ledger is currently called the XRP ledger. Their aim was to create a faster, cheaper, and more energy efficient alternative to the Bitcoin blockchain, which was the first blockchain ledger which was introduced in 2009. And so they made a number of changes. So you remember Bitcoin is energy intensive because of proof of work. So they wanted to get away from the proof of work model. They also wanted to change the currency issuance model. So when the XRP ledger launched in 2012, its source code generated a fixed supply of 100 billion XRP. XRP is a native digital token of the XRP ledger, and the XRP ledger requires XRP to operate. So this is a very different currency issuance model. With Bitcoin, basically new Bitcoin is issued every 10 minutes or so when a new block is issued. Whereas with the XRP ledger, all of it was created up front. So in 2012, Brito, Larsons, and McCaleb founded a company called Ripple Labs. Of the 100 billion XRP generated by the XRP ledger's software code, the three founders kept 20 billion of it for themselves, including Larson receiving 9 billion, and then they gave the other 80 billion XRP to this company, Ripple Labs. So RippleNet is primarily promoted for providing international transfers. The mission of Ripple Labs is to realize an internet of value by using technology to facilitate the transfer of value across the internet. Ripple seeks to modernize international payments by developing a global payments network for international currency transfers. And in fact, they developed a software product called RippleNet, which allows customers to clear and settle cross-border financial transactions on mutually agreed upon terms. One feature of RippleNet is known as on-demand liquidity, which facilitates cross-border transactions by allowing customers to exchange fiat currency, for example, US dollars for XRP, and then the XRP for another fiat currency, for example, Mexican pesos. So to make it easy to transfer dollars into pesos, using XRP as an intermediary currency. Now, anyone who's done any international transactions in the past using wires knows that the wires process, has significant fees, as well as it takes a while. If you send a wire, you're sending funds by wire, it could take you up to 3 weeks before the recipient receives the money. In theory, it should be less than a week, but in some cases, it does take several weeks. And you could be spending fees by the spender, as well as fees by the receiver to make that wire happen. And so your fees for a wire could be $40 or $100, depending on where you are and so forth. Now, anyone who sent cryptocurrency over the internet knows that depending on the cryptocurrency you choose, the fees and transactions can be quite tiny. I sent some Ethereum around the world, and it got there within minutes, and the fees were like $1 or $2 to send it around the world. So internet currencies, digital currencies like XRP or Bitcoin or Ethereum do have the ability to make international payments much more efficiently than the traditional wire system. So now let's talk about what Ripple did with the XRP it had. I mentioned they had about 80 billion XRP originally, and throughout this lecture, I'm going to be talking about my analysis stopping at 2020 because that's where the case facts analysis stopped, was at 2020. So that's why you'll see these references to 2020 throughout this presentation on the SEC versus Ripple Labs case. So at all times before the end of 2020, Ripple owned between 50 and 80 billion XRP. They started off with 80 and then they used some of it. And between 2013 through 2020, Ripple Labs engaged in various sales and distributions of the XRP token. And the court broke these sales down into 4 different groups, which I will continue to use for my analysis as well in these slides. What we'll call the institutional sales, which is selling to various institutions. Programmatic sales, which is selling on exchanges like Kraken and Coinbase and so FTX. Other distributions, which is other ways of distributing the XRP without doing a sale to an institution or through an exchange. And then personal sales by the 2 executives who are part of this case, Larson and Garlinghouse. So Ripple, through wholly owned subsidiaries, sold XRP directly to certain counterparties, primarily institutional buyers, hedge funds, and so on, under written contracts, which, written sales agreements and so on, which we're going to call the institutional sales. And the SEC alleges that Ripple sold approximately $728.9 million worth of XRP in these institutional sales. So that's a lot of money to receive for XRP. Second, Ripple sold XRP on digital asset exchanges programmatically or through the use of trading algorithms. These are probably centralized exchanges, although near the end of that, there were some decentralized exchanges, so it's possible they were also decentralized exchanges. Ripple's XRP sales on these digital asset exchanges were blind bid as transactions. Ripple didn't know who was buying the XRP, and the purchasers didn't know who was selling it. The SEC alleges that Ripple sold approximately $757.6 million worth of XRP in programmatic sales. So we had 728 institutional sales, 757 programmatic sales. That's $1.5 billion worth of sales of cryptocurrency between the two. Ripple also distributed XRP as a form of payment for services. For example, they distributed XRP to the employees as a form of compensation for employees. They also distribute XRP in conjunction with various initiatives like an Xpring initiative to fund third parties that would develop new applications for XRPs and the XRP ledgers. This is oftentimes referred to as grants. So in sum, the SEC alleges that Ripple had a recognized revenue of $609 million from its distributions of XRP to individuals and entities in exchange for services. If they'd wanted to get the same benefit from paying, US dollars, they think the equivalent would be $609 million. All right, so those are our 3 categories of the other distributions, the programmatic sales, and the institutional sales. There's also an analysis of the individual defendants, Larson and Garlinghouse. In addition to Ripple's sales and distributions, Larson and Garlinghouse offered and sold XRP in their individual capacities. Larson was the original CEO of Ripple Labs, and he was replaced by Garlinghouse eventually, and Garlinghouse was the current CEO. So Larson and Garlinghouse offered and sold XRP in their individual capacities from at least 2013 through 2020. Larson sold XRP in digital asset exchanges programmatically and made at least $450 million from his sales. Garlinghouse became CEO in 2017, and from 2017 through 2020, Garlinghouse sold XRP in digital asset exchanges, and the SEC is alleging that Garlinghouse sold approximately $150 million in XRP during that period. So that's another $600 million worth of XRP being put on exchanges just by these 2 individuals. Now, the defendants did not file a registration statement as to any offers or sales of XRP. Ripple did not publicly file any financial statements or other periodic reports or EDGAR filings with the SEC for Ripple or XRP, such as Forms 10Q, 10K, or 8K related to XRP. And these are the forms that are typically filed by companies who are doing securities offerings. Ripple also did a lot of marketing for the XRP currency. Since at least 2013, Ripple has prepared and distributed documents that describe the company's operations, the XRP trading market, and the XRP ledger. For example, in 2013 and 2014, Ripple created 3 brochures: a Ripple for Gateways brochures, a Ripple Primer, and a deep dive for financial professionals. These documents were distributed publicly to prospective and existing XRP investors and outline, among other things, the relationship between XRP and Ripple's business model. Ripple circulated versions of the Gateways brochure to more than 100 third parties. The primer had widespread distribution, and the deep dive was posted on Ripple's website and sent to over 100 people. Later, starting at the end of 2016, Ripple began to publish on its website quarterly XRP market reports, which were intended to provide clarity and visibility about Ripple's market activities. Now, Ripple also received legal advice about selling XRP. In February 2012, before the XRP ledger was publicly launched, Ripple's founders, including Larson, received from the Perkins Coie law firm a memo which sought to review the proposed product and business structure, analyze the legal risks associated with Ripple Labs, and recommend steps to mitigate these risks. The memo analyzed, among other things, the legal risks associated with selling XRP. Specifically, it stated that if sold to investors, XRP tokens are likely to be securities. And to the extent that the founder's issuance of XRP does not involve an investment of money, there's a low risk that XRP will be considered an investment contract. And that was getting at the first element of the Howey test, which we'll talk about later. A subsequent legal memo stated that the memorandum states that although we believe that a compelling argument can be made that XRP tokens do not constitute securities under federal securities law, given the lack of applicable case law, we believe there is some risk, albeit small, that the SEC disagrees with our analysis. The memo further stated that the more that the founders and Ripple promote XRP as an investment opportunity, the more likely it is that the SEC will take action and argue that XRP tokens are investment contracts. So just a little background on the case. On December 22nd of 2020, the SEC sued the defendants. The fact discovery and expert discovery phases of the case took place in 2021 and 2022. In September 13th, 2022, the parties filed cross motions for summary judgment. The court also received amicus briefs from several interested parties, and this decision came from the court on July 13th of 2023. So just a review of summary judgment. Summary judgment is appropriate where the record shows that there is no genuine dispute as to any material fact, and that the moving party is entitled to judgment as a matter of law. A genuine dispute exists if the evidence is such that a reasonable jury could return a verdict for the non-moving party. So what is the applicable law that the court had to deal with? The applicable law is Section 5 of the Securities Act. Under Section 5 of the Securities Act, it is unlawful for any person, directly or indirectly, to offer to sell, offer to buy, or purchase or sell a security unless a registration statement is in effect or has been filed with the SEC as to the offer and sale of such security to the public. To prove a violation of Section 5, the SEC must show that no registration statement was filed or in effect as to the transaction, and that the defendant directly or indirectly offered to sell or sold the securities through interstate commerce. So the question is, did the defendants sell a security? The defendants don't dispute that they offered to sell and sold XRP through interstate commerce. They also do not dispute that they did not file a registration statement with the SEC for any offer or sale of XRP. The only question is whether or not defendants offered to sell or did in fact sell XRP as a security. And specifically, the SEC alleges that the defendants sold XRP as a type of a security called an investment contract, which is defined by the Securities Act. Defendants argue that they did not sell XRP as an investment contract, and therefore they weren't required to register, and therefore everything they did was fine. So let's talk about the Howey test. In a Supreme Court case, SEC versus W.J. Howie Company, the Supreme Court held that under the Securities Act, an investment contract is a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. Now, this is often referred to as three separate prongs, and so we're going to identify these, analyze each of these prongs separately. The first one being, was there an investment of money? The second one, is there a common enterprise? And the third is the individual led to expect profits solely from the efforts of the promoter or the third party? Now, in analyzing whether a contract, transaction, or scheme is an investment contract, form should be disregarded for substance, and the emphasis should be on the economic reality and the totality of the circumstances. So it shouldn't matter whether the contract is called an investment contract or a real estate contract. The question is, does it have these three prongs of the Howey test? If all three of those are present, then it's considered an investment contract, regardless of what the actual contract or transaction is called. That's what we're getting at with this totality of the circumstances. And a commodity can be the subject of an investment contract. Howey and in subsequent cases have held that a variety of tangible and intangible assets can be the subject of an investment contract. Orange groves in the Howey case, whiskey casks, payphones, condominiums, beavers, digital tokens, all of these have been found to be commodities that were the subject of investment contracts, depending on the totality of the circumstances. In each of these cases, the subject of the investment contract was a standalone commodity, which was not itself inherently an investment contract. For instance, if the original citrus groves in Howey were later resold, the resales may not have been an investment contract, depending on the totality of circumstances surrounding the subsequent transaction. So the SEC alleges that these institutional sales were distributions of XRP into public markets through conduits, and that some institutional buyers were buying XRP as brokers, or others simply sold it as part of their trading strategies. And the first prong of Howey examines whether an investment of money was part of the relevant transaction. Here, the institutional sales invested money by providing US dollars, fiat, or other currency in exchange for XRP. The defendants do not dispute there was a payment of money, and the court found that therefore the first element of Howey has been satisfied, that there was an investment of money for the institutional sales. And we're going to look at each of these separately. We'll look at the institutional sales first, then we'll look at programmatic sales, then we'll look at the other distributions, and then the individual sales. With regards to the second prong of Howey, the existence of a common enterprise, when we look at the institutional sales, the court was satisfied that the second prong was also satisfied. Now, the existence of the common enterprise can be demonstrated through a showing of horizontal commonality. Horizontal commonality exists where the investor's assets are pooled and the fortunes of each investor are tied to the fortune of other investors, as well as to the success of the overall enterprise. Here, the undisputed record shows the existence of horizontal commonality among the institutional sales. Ripple pooled the proceeds of its institutional sales into a network of bank accounts under the name of its various subsidiaries. Although there were different bank accounts for each subsidiary, Ripple Labs controlled all of the accounts and used the funds raised from the institutional sales to finance the operations of Ripple. Further, each institutional buyer's ability to profit was tied to Ripple Labs' fortunes and the fortunes of the other institutional buyers, because all institutional buyers received the same fungible XRP. When the value of XRP rose, all the institutional buyers profited in proportion to their XRP holdings. Now let's take a look at the Howey third prong, which again, the court found that institutional sales satisfied the Howey third prong. So the third prong of Howey examines whether the economic reality surrounding Ripple's institutional sales led the institutional buyers to have a reasonable expectation of profits to be derived from the entrepreneurial and managerial efforts of others. In this context, profit means an income or return to include, for example, dividends, other periodic payments, or an increased value of the investment. Based on the totality of the circumstances, The district court found that the reasonable investors situated in the position of the institutional buyers would have purchased XRP with the expectation that they're going to derive profits from Ripple's efforts to promote XRP. From Ripple's communications, marketing campaign, and the nature of the institutional sales, reasonable investors would understand that Ripple Labs is going to use the capital it receives from the institutional sales to improve the market for XRP and develop uses for the XRP ledger, thereby increasing the value of XRP and therefore satisfying Howey's third prong. All right, let's look at the other uses of Ripple. Other uses of XRP by Ripple Labs. And we'll start with programmatic sales. And here, the district court found that the programmatic sales did not satisfy the third prong of Howey. Having considered the economic reality of the programmatic sales, the court concludes that the undisputed record does not establish the third prong of Howey. Whereas the institutional buyers reasonably expected that Ripple Labs would use the capital received from its sales to improve the XRP ecosystem and increase the price of XRP, the programmatic buyers could not reasonably expect the same. Indeed, remember, the Ripple's programmatic sales were blind bid and ask transactions, and therefore programmatic buyers didn't know who was receiving their funds, and so they could not have known if their payment of money went to Ripple or any other seller. And since 2017, Ripple's programmatic sales represented less than 1% of the global XRP trading volume. So over 99% of over 99% of XRP transactions was going to other people besides Ripple Labs. And therefore, there's no reason why anyone would expect that if they're doing a blind bid ask, that those funds are necessarily going to Ripple Labs. Furthermore, with respect to programmatic sales, Ripple didn't make any promises or offers to the people purchasing XRP that they were going to support the XRP ledger, and the purchasers didn't know who was selling it. And in fact, many of the programmatic buyers were entirely aware that Ripple Labs even existed. They were acquiring XRP because they wanted XRP, not because Ripple Labs supported it. The programmatic sales were not made pursuant to contracts that contained lockup provisions, resale restrictions, indemnification clauses, or statement of purpose, which is different from the institutional sales agreements that typically included those clauses. And so, having considered the economic reality and totality of circumstances, the court concludes that Ripple's programmatic sales of XRP did not constitute the offer and sale investment contracts. And this is actually a really important point here, this considering the totality of the circumstances, because there's a number of different facts that play into why the court didn't find that programmatic sales of XRP were an investment contract. So as far as programmatic sales are concerned, they are not an investment contract under the Howey test, according to the district court. All right, let's move on to the next one. Let's look at the other distributions. So the district court found that the other distributions did not satisfy the first prong of Howey, that there's an investment of money as part of the transaction or scheme. Here, the factual records show that the recipients of the distributions didn't pay money or some other consideration to Ripple. Instead, Ripple was paying consideration to the employees and companies. Ripple was paying XRP. And so again, it doesn't satisfy the first prong of Howey. And so of the three different aspects of Ripple Labs' use of XRP, the institutional sales satisfied Howey, but the other distributions and the programmatic sales did not satisfy the Howey test for an investment contract. All right, let's look at the individual defendants. Larson and Garlinghouse did not satisfy the Howey third prong, similar to Ripple Labs' programmatic sales, because Larson and Garlinghouse's sales of XRP were all programmatic sales on digital asset exchanges through blind bid and ask transactions. They didn't know to whom they sold their XRP, and the buyers didn't know the identity of the sellers. And therefore, as a matter of law, the factual record cannot establish that the third Howey prong as to the personal transactions by Larson and Garlinghouse. All right, there was some additional issues that the court dealt with besides the primary issues of dealing with whether or not the various transactions involving XRP were investment contracts under the Howey test. The first question, other issue that the court dealt with was the defendant's due process defenses. So the defendants each assert a fair notice defense, claiming the SEC violated their due process rights. Larson and Garlinghouse also assert an as-applied vagueness defense based on the same due process principles. The court stated that a fundamental principle in our legal system is that laws which regulate persons or entities have to give fair notice of conduct that is forbidden or required. This clarity requirement is essential to protections provided by the Due Process Clause of the Fifth Amendment and requires the invalidation of laws that are impermissibly vague. So the district court rejected defendants' fair notice and vagueness defenses as to the institutional sales. Howey set forth a clear test for determining what constitutes an investment contract. Defendants focused on the SEC's failure to issue guidance on digital assets and its inconsistent statements and approaches to regulating the sales of digital assets as investment contracts. And the court stated that the SEC's approach to enforcement, at least as to the institutional sales, is consistent with the enforcement actions that the agency has brought relating to the sale of other digital assets to buyers pursuant to written contracts and for the purpose of fundraising. And there have been a lot of enforcement actions over the years that the court is referring to here. Next, the court took a look at Larson and Garlinghouse's aiding and abetting of Ripple's violations. The SEC also moved for summary judgment on its aiding and abetting claim against the executives of Larson and Garlinghouse. To establish liability for aiding and abetting a securities violation, the SEC must show, one, the existence of a securities law violation by the primary party, as opposed to the aiding and abetting. So if they can show that Ripple Labs had a securities law violation, then they can pursue aiding and abetting against the executives. Two, it has to have knowledge of the violation on part of the aider and abetter. So the executive has to know about the violation. Three, there has to be substantial assistance by the aider and abetter in the achievement of the primary violation. So the executive has to provide substantial assistance in the violation. And the court recognized that there are disputed issues of fact regarding knowledge of the violation and whether or not the parties provided substantial assistance, whether the individual dependents knew or recklessly disregarded the facts regarding the Howey test for the institutional sales, and whether or not they provided substantial assistance. And therefore, the court denied the motion for summary judgment for this particular claim. So just to summarize, the facts established that the institutional sales of XRP were an investment contract under the Howey test. The facts did not establish the programmatic sales of XRP were an investment contract in the Howey test, because the facts do not support that profit would come from the efforts of a third party, which is the third prong of the Howey test. And the purchasers did not know who they were purchasing from. Over 99% of the transactions in XRP since 2017 were not with Ripple Labs, and some purchasers did not even know that Ripple Labs existed. And the facts did not establish that the other distributions of XRP were an investment contract on the Howey test, because the facts do not support that there was an investment of money, which is the first prong of the Howey test. And the facts did not establish that the individual defendants' transactions were not an investment contract for similar reasons to programmatic sales. And so that's where we were on summary judgment. Let's talk about the current status of SEC versus Ripple. So the SEC asked the court for permission to immediately appeal the decision. And that's as opposed to waiting for a trial to be completed. Now that is up to the discretion of the court, and the court denied the appeal. There will be an appeal as of right after the court is over, if either of the parties chooses to appeal after the district court case decision is over. But since the case is not over, we're just at the summary judgment stage. They asked to appeal, and that was denied. SEC has subsequently dropped the charges of aiding and abetting against Larson and Garlinghouse. Those were the only charges that would still have had to go to trial. Therefore, essentially at this point, we're going to sentencing. The sentencing should happen in the next few months, and at that point, after the sentencing is over, at that point, the parties will be able to appeal as of right to the U.S. Court of Appeals. and it's possible we'll see appeals by either the SEC or Ripple or both. So thank you for listening to this video on SEC versus Ripple.